Fire me then. I have free speech. This is a public entity. You want to go down that road?
These records.
Okay, wait a minute. One thing at a time. I'm wanting to know what you gave your client. Did you give him some of this alleged victim's medical records?
No.
No, I did not.
Then how did they get out into the public domain?
I have no idea, Judge.
Well, welcome to part 2 of Jill is a Liar. And she got caught red-handed. Now, previously in part 1, you seen that Jill had made an accusation and accused the defense, Robert Walker Jr. and his attorney, for somehow leaking information to us that they never even got. And then it was, they leaked the MRI. We have no records, as I mentioned in part 1. We have no records, received no records, had no contact with Mr. House, Robert Walker Jr.'s attorney, or Robert Walker Jr. up to 2 hours before this hearing. So how is it weeks and weeks before this hearing, somehow we obtained medical records? We haven't. We have none. And we're going to go over some of that in this video. So let's continue, and I'll try to interrupt less and less in this video. But if there's something key that I want to address, I will stop the video and address it. But other than that, let's look and see what other lies Jill is going to say.
They haven't.
So you're telling me, Mr. House, as an officer of the court, that you did not provide copies of these materials when you received them to anyone else, including your own client?
I provided my clients the videos that were given to me, and I provided them copies of pleadings. And
I'm narrowly focusing on medical records. I don't care about pleadings. Okay. I don't care about videos right now. What I'm concerned about is some private, HIPAA-protected medical records for an alleged victim in this case, which in this court's opinion should never be turned over to a criminal defendant. Counsel's entitled to see them. Counsel's entitled to discuss those with his client, and even under certain circumstances would be enabled to share them to let the client look at them, for example, in his office or conference room. But as far as ever giving him copies, that shouldn't happen. And I think that's well established. And quite frankly, Ms. Gillette would have been well within her rights to demand a protective order upon turning over those records signed by counsel that he will follow those rules. But Mr. House, you're giving me the impression that you never turned them over to Mr. Walker.
That's right.
Which again makes me wonder, why are they in the public domain? Who did turn them over then?
So I'm going to pause right here. And I'm going to say what information was released and who had it, how did we get it, and who released it to the public. Now, look at these screenshots here. Go to this channel, Mike with the Lawrence Accountability. Watch this video, and you'll see in the description of this video is timestamp of all the information that Jill herself allowed to be posted on a public domain site like YouTube. She is the one that had this preliminary hearing allowed to be published on YouTube via a Zoom court hearing, preliminary hearing. And you'll see all the detailed information of questions Jill was asking Amy Bliss, Richard Eric Watts, and their testimony under oath broadcast live about their medical history and injuries. Where did we get the information? Well, old Squishy Gardner got this video and posted it, republished it on YouTube. and then we found it. It was shared to us. It was brought to our attention. So we used that information and shared it. That is all the information we had. So we did not obtain any records or documents of medical. We obtained this video that you'll see here. And you can go through that video and see the timeline of everything that we got and how we got it. So Jill is a liar. Busted. She leaked the information. She had a responsibility to make sure that the questioning of those medical records or medical history of these witnesses was not to be published on a public domain such as YouTube. That's how the information we got was released to the public. It was Jill. It was 13 District Court that released it to the public.
Or not.
I don't know. I haven't seen them.
Well, first of all, Mr. House, are you aware that these records are being discussed publicly on some sort of website or program?
Miss Gillette has informed me of the social media, so to speak, incidents recently, and I don't get involved in social media. I've told my clients that we're going to try our case in the court, not in the newspaper, not on social media, and I stand with that statement.
All right. Well, certainly, Mr. House, your track record with the court over a period of years speaks for itself. If you're telling this court that you did not turn these records over even to your client, then I'll take that at face value at this point, Mr. House. But it still makes me wonder, then, from what other source could any other person outside this case access these records? I suppose it could be leaked by the county attorney's office. I would find that extraordinary, but I suppose that's a possibility. Or from the medical providers themselves, which also seems quite unlikely given their adherence to HIPAA standards. Sometimes even to ridiculous lengths, they follow HIPAA standards. All right, so, but Ms. Gillette, I need something more specific than a while back when you received these California records. Surely there's a date certain you can identify.
When Deputy Watts moved back to the area, they would have been available to me. He moved back in around April. He brought them in to me to copy, but he's been scared to bring them in to be copied. And so with his being scared of having them be copied and distributed further as to everything else going on, I asked him to go ahead and bring them in so that I could have them. And we did so. He had been writing to and calling the doctors in California for quite some time. So in the last several weeks, I've asked him to come in and re-sign releases with me so that I can see if I can obtain them by myself with his releases. I have copies of everything that was in his possession. The doctors in California have still not responded to my request or his requests, but I have everything that is in his possession. I would ask that if it's not that they have to come look at the records, like if they need or want an expert to look at them, that there is a non-dissemination order on anything further that is given out, any MRI records that would be in the defendant's possession or his son's possession, because I understand that his son has also had the videos of this case. And Mr. House is the person who told me that. And all of these social media presences have copies of all of these videos and have been running them on websites like crazy. That all of that has to be,
Go ahead.
All of that has to be protected and not disseminated. Any medical records in anyone's possession other than Mr. House should be destroyed. It should not be out there. It should not be further disseminated anywhere. The medical records, if I need to give them to Mr. House for his expert, should not be disseminated further than Mr. House or the expert. It needs to be under complete 100% seal. I would prefer they have to come look at them because of what's happened with all the leakage of stuff out of this case. I mean, the videos are being edited, they're being still shot, they're being put on social media daily. All of the witness statements and the affidavits are on the website. The actual victim witness statements to the disorderly conduct of the personnel of the Elk County. And we're not talking about deputies. We're talking about office staff in the other offices that are employees of Elk County have been leaked and are on the public websites. The paper documentation that Mr. House gave his client of his case to look at have all been leaked on these public websites. The victims' names and information should not be out there before trial. The copies of their statements in their handwriting should not be being posted on public websites. That shows how much of the paper documentation has been given out and not just the videos, because they're all made public right now, and you can go live on YouTube. And if I have to log in my computer and scroll up on YouTube these sites for you to watch them, we can take time to do that. Or I can send the court the links so the court can click on the links and watch these videos that show.
I don't want to watch the videos.
Stuff.
The only time that these videos are relevant in this court's view is when they're presented in court.
Now I want you to pay attention to what Jill just said right there. A public employee, county employee, the witness that she's speaking of was named Summer. She was a dispatcher. She's the complainant of the disorderly conduct. And Amy Bliss is the complainant of a disorderly conduct. An officer, a deputy, and the dispatcher, both county employees. You have the right to redress grievances with your government. That includes a deputy. That includes the dispatcher, a county employee, any public employee, county employee, city employee, a member of the government, elected or not. If they're employed, you have the right to redress your grievances with those people. That's your government. Those are the front faces of your government. You have the right to redress grievances. And what Jill's saying here is, let's hide our lies. Hide our lies. We don't want to be transparent, because if we're transparent about all this crap, we're going to be held accountable. So they don't want transparency, and they don't want it held accountable. Transparency and accountability is, keep that down. We don't want that around here. That's why if you walk into a sheriff's office, they demand your ID just to speak to a deputy.
He could have just told us. I didn't realize we were on the wrong side of the building. Yeah, we'd like to see the sheriff, please.
Okay, I need to see both your IDs.
No, ma'am, we'd like to see the sheriff, please.
Okay, you don't get to do nothing unless I get to see your ID.
Ma'am, we're citizens of the state of Kansas, and we're here to do open records work.
Every citizen that comes in the foyer has to give me their ID.
No, ma'am, that's not the way the law works.
Well, I don't know whose law you're talking about.
Ma'am, we just saw the sheriff pull up. Would you please ask him to come out and speak with us?
You did not see no, you did not.
That's why they demand who you are, your name, and where you're going in that courthouse, because they don't want you to see what they've got going on in there. Makes me sick.
Good morning, where are you headed?
To the sheriff's department.
Okay, you're at the courthouse.
Okay, where's the sheriff's department? I thought it was here.
Can I ask you what your name is?
Michael?
And where are you from, Michael?
I don't need to answer those questions, ma'am. You're asking me where I'm from?
And the victim statements should not be being taken photos of or scanned.
And your position that those are protected documents comes from where?
Judge, the
You filed
evidence,
these public charges identifying these people as potential victims in the case. So it's been a matter of public record ever since you filed charges in this case that they're victims in the case.
that are made public. The evidence is the evidence that is sealed until the time of trial. If the court looks at the state's motion, especially in State v. Alston, and that's where the state was leaking evidence, not a defendant. They wanted to sanction the state for leaking evidence, including statements and affidavits, and it is said that only the public record should be distributed prior to trial. What is in victim statements, what is in affidavits, what is in video is supposed to remain confidential until the time of trial. Public information that is gleaned by a reporter in a courtroom being there publicly may be talked about from a public hearing, but the statements, the affidavits, copies of those documents are not to be made public until after the trial is occurred. And they're not. They're being used rampantly in State v. Huffman, the freedom of speech against the regulation. The court has to balance and weigh that. And I quote State v. Huffman. Further, I also quote the U.S. Supreme Court in Gillette Company versus DePasco, which is 433 U.S. 368, 1979, as to proceedings in the courtroom and who is allowed in and who's not allowed in, and how narrowly tailored things must be for rules on excluding people or things from the courtroom, or how to protect things. And in this case, those documents are supposed to remain as part of the sealed case until time of trial. The only thing that is public is what are public documents going back and forth in the court's public record. But the affidavit is actually sealed, and the victim statements are evidence, not public documents in the public record of the public court file that you can find on the Odyssey system, is what Kansas uses. Our eFlex filings public system is called Odyssey. What's in Odyssey is public. What's in the discovery is not. And the laws and the cases that I have cited in my motion are what shows that that is not to be disclosed until after the trial. If media wants to do some kind of story on it afterward, make a movie out of a case, those documents are sealed until the trial. And the fact that they're being posted out there has allowed these social and special interest groups to have copies of this stuff, addresses of people that should have been redacted by the defense when they receive them, because we have to give the defense unredacted copies. The defendant should have redacted copies, if any. And the problem that we're running into is all of this is being posted publicly on YouTube channels daily. And I've also filed a motion to issue a temporary, and I wanted an ex parte, but I want an injunction of protective order until the final hearing and trial to maintain the status quo. At this point, almost all the evidence is out there from Mr. Walker himself.
Again, I want to, the lie, the lie after lie after lie. We never had no contact with Robert Walker. Robert Walker did not give us any information, no videos, no documents, no nothing. Didn't even speak to Robert Walker Jr. till 2 hours before this pre-trial hearing, and it was just over a post that he posted. I could not see it. Someone told me about it. So I went and looked at this post and seen, or I had added him as a friend, read his post, seen that he misprinted and mistakenly accused them of violating his Third Amendment right. And I corrected him on that, said unless you have troops quartered in your house, the Third Amendment was never violated on you. And he goes, yep, that was a misprint, my bad. And that was all the contact and information we ever shared with each other. Other than that, I haven't talked to Robert Walker Jr. up to this point, to this hearing. It's a blatant lie. She's just trying to cover her butt right now. And sickening. This frustrates and irritates the hell out of me that our government, elected official, elected county attorney, lies right there in court to the judge on transcripts now, trying to say that we are the ones exposing medical information. when they're the ones that posted the Zoom on a YouTube channel, and then a guy like old Squishy Gardner got a hold of it and shared it to the world, and then that's how we got it. But we're the ones to blame when Jill and 13 District Court's the one that put it out there on the public domain, and then old Squishy Gardner got it, recorded it, and shared it. But we're to blame?
Messing with his own jury trial because him and his family have been talking to, interviewed by, giving information to two social media personas that are posting everything on a YouTube channel and live streaming from the courthouse and in the county. In fact, this week, Mr. Walker's wife was talking all about this case on a live stream, called my office. He's shaking his head yes that they did, and called my office saying they thought they were afraid of deputies because they've been down here making threats towards the deputies, and now they think they're afraid of them because they've made so many threats to harm them and me.
Okay, another lie by Jill. No threats were ever made by us, our videos, or any live stream. You can go back and check them. Go back and check them. And Jill, if you're going to make threats or accusations of threats from us, Robert Walker Jr. or Jill, Jennifer, his wife, Michael with Lawrence Accountability, Justin, the rabble rouser, if you're going to accuse us, all of us, of making threats, you better bring the evidence. Because right now you're looking at slander and defamation. Jill, this is your government right here, guys. This is your government. Lying to cover their butts, to turn the picture and try to make us the perpetrators and them the victims. The victim is Robert Walker Jr. from your corrupt, false arrest and false allegations of disorderly conduct. And now you're ramping up all these charges. This is what gets me so frustrated and ticked off because I've been railroaded by people like this. And this is why I do these videos. Exposing this crap.
2 weeks ago, as of yesterday, one of these social media followers called my office and asked if I was a Republican or Democrat, which my secretary said she didn't really know because she hadn't asked me, and that they wanted to break down my door, drag me out on the courthouse lawn, and string me up in a tree. That's disturbing, extremely disturbing. And that's what they told my secretary. So I have had to hire extra security to follow me around. And on the court day, I have extra security that is going to follow me around to watch my back so I can concentrate on my job, because I've had 3 death threats in 2 weeks. And the sheriff is having to bring in extra security. So part of my motion is also for additional security for the trial, which the sheriff is already trying to get in.
That's been previously addressed by court administration.
For a limit of recording by press, especially the 2 entities, because it has to be very narrowly tailored, that these 2 entities that keep putting everything on and coming to the courthouse to live stream, that they cannot live stream the jury trial, they cannot broadcast it, and they not be allowed in because they seem to like to sneak stuff in, and that they not be allowed in the courtroom. Now, if you read my full motion, I fully encourage the legal rule following press.
The legal rule following press. So I have a question for Jill. What makes you legal when it comes to press? I think the federal government, our founding document, the very document you swore an oath to uphold, the First Amendment, grants me to be a member of the press. It blows my mind on that statement right there alone. rule following. You know what rule following is? You got to paint the story in a light that shines on her to make her look glorified and a winning prosecutor. That's the rule she wants that follows. She doesn't want the truth to be exposed. No, 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 no. That breaks the rules.
Press, especially our local press, that have never abused their privileges to record things, be allowed. I fully encourage the First Amendment for those who do it appropriately. But the two entities that are
Mr. Walker,
listed.
why do you have to keep acting up? I don't care what your opinions are along the way. If I want to know your opinion on something, Mr. Walker, I will ask you specifically. I don't need you to give me indications by the shaking of your head as to whether you approve or disapprove of what's being said. So stop it.
The two,
All right. We're just jumping so far out ahead that let me address the first issue in this case. Mr. House, I will enter an order at this time precluding either the state or the defense from publicly disseminating any of the case materials in this case that are not a matter of public record already. And that would include any affidavits, witness statements, or any other materials that were gathered in discovery that are not part of a public filing that's already in a public court file. Whether you've actually been guilty of disseminating that in the past or not, I'm putting an order precluding it at this time. That same order applies to Mr. Walker. There is nothing to be gained by public dissemination of these materials. It very well may interfere with the ability of one or both parties to have a fair trial. Therefore, the records, and I realize that the cat may be out of the bag already, but from this point forward, this court will enter a specific order barring both sides from publicly disseminating these records without a prior written court order from this court. Any questions about that, Mr. House?
None, Your Honor.
Okay. Ms. Gillette, any questions?
not about that.
Furthermore, this court has no intention of allowing any recording in the courtroom, whether it be by video, tape recording, cell phone, or any other manner. There is going to be an official record taken in the case. The court reporter obviously will have the ability to record and or take down any testimony in the particular case, but I will entrust that solely to court staff. I'm not going to pick and choose among people in the press about who can record and who can't. If this has been an issue in this case, the court's going to put a stop to it, and the court's not going to allow any recording. It is a public trial, and people will be allowed to attend and watch the trial proceedings. They may not always be allowed in the courtroom itself. If not, we will provide an appropriate closed circuit television or some other ability for them to watch. But there will be no recording of any of the trial proceedings in the case. That should address Ms. Gillette's concern in that regard. Furthermore, this court is, at least at first glance, disturbed about the state's reticence to turn over necessary discovery materials. One of the critical issues in the case that they intend to prosecute in regards to this matter is the alleged injury suffered by one officer in this case. In fact, they allege very serious injuries in the case. In the second amended information in this case, aggravated battery on a law enforcement officer, the allegation is physical contact was causing great bodily harm or disfigurement. Therefore, the medical condition of the victim is relevant, and the medical condition of the victim and the medical testimony or evidence that supports the state's claim that there was either great bodily harm or disfigurement. And I don't know, at some point you're going to have to elect whether he was disfigured or great bodily harm or some combination of the two. But the reality is, either way, there's going to need to be medical testimony in support of it. It appears that the state has had possession of these materials knowing that they're relevant to a material issue and has refused to turn them over to the defense. Now, I do understand Ms. Gillette's well-founded concerns. It seems to me, though, Ms. Gillette, that why didn't you just ask Mr. House, an experienced and actually quite reasonable lawyer, to sign off on a protective order addressing all of your concerns before you hand him the materials? Is there a reason why you didn't do that?
Normally it's ordered by the court.
Well, I would have likely signed off on the order that was agreed upon by counsel in the case. It would be an extraordinary situation that I wouldn't. Or you could have scheduled a motion with this court and we could have had a hearing on it. But I am disturbed about the fact that the state's sitting on important medical records, which is very material to the most serious charge pending in this case, and they haven't turned them over to the defense so that the defense can adequately prepare for this trial. Now, Mr. House at this point believes that the breach is so egregious of the prosecutor's duties that he believes it should lead to dismissal. Am I right, Mr. House?
That's what I've alleged. Now, I indicated in my motion, I've had a good working relationship with the county attorney over the years and will continue to have one. But I alleged in my motion, and she told me that she was having trouble getting these records. And I believe that.
Me too.
But we don't have them. We have preliminary hearing testimony that involves the alleged victim having a back problem before this ever happened. And so that's why we need to have an expert look at those new records.
All right. Well, it's obvious for this court to make a determination today, here, literally on the eve of trial, or very, very close to our trial date, that the defense would be materially compromised if these medical records were not turned over to the defense in adequate time for them to get their own expert opinion. Do you dispute that, Ms. Gillette?
If they need an expert to look at them, then they will need time.
I also would agree with the prosecutor in this case that these records, once turned over, are to be turned over solely to Mr. House. Mr. House would be authorized to turn those over to a retained expert for purposes of examination of those records in order for them to make an expert determination regarding the injuries allegedly suffered by this officer. These records are not to be turned over to Mr. Walker. The defense position is protected through the attorney. You may discuss the content of those records with your client privately. Those discussions are not to be disseminated to others because, quite frankly, I don't know why anyone else would need to hear it. And I think that there just needs to be very strict protocols followed in your office, Mr. House, to make sure that there's no linkage, as Ms. Gillette calls it, of these records to anyone else.
Yes, Your Honor.
Once they're turned over. Any questions about any of that, Mr. House?
No, Your Honor. I assume that the expert is a doctor in Tulsa, and I can mail those records to him, but I'll do it with the understanding that he can't share them with anyone.
That's correct. I think they would know that as a matter of course, but my order does also apply to any expert or expert agency to which these records are sent. But they are not to disseminate those to anyone else without specific authorization from this court. And I think they would know that because of their own HIPAA standards that they have to follow. But if an order is drafted from today, that it should cover the doctor or the expert agency as well. All right. The title of your motion, Ms. Gillette, ran on for about 6 sentences and covers a number of different matters. Motion for protective order, which this court has essentially granted. non-dissemination order, which I presume is part of the protective order. Seal certain documents. What documents need to be sealed? Sealing documents to this court is involved in records of the court. So what do we need to seal in the records of the court?
Your Honor, I submitted the exhibits of some of the things that have been being said and done that are necessary for extra security. They contain initials or last names of specific dispatchers that have been harassed in the phone logs. There are pictures of the websites of the two entities that are, and frankly, I don't want to say their names on the record because I don't want to give any more credence to their names. But if you want to know who they are, I will tell you.
Okay, just a minute. We're talking about sealing court records. So have you already filed these in the court?
Yes, they're filed right now, sealed, and you can make the decision to leave them sealed or unsealed.
I'm going to leave them sealed.
Okay.
I have
And
no intention of currently unsealing any of those documents that involve these private matters.
when the medical records come into evidence during the jury trial, I would ask that the evidence in the jury trial with all medical records be made sealed so that they are not public. And if there are any requests of public for exhibits, those are sealed. They're for the jury, they're for the judge, they're for the parties. They're not for media personas to go out and make money off of.
Court is inclined to agree. Any objection to that request, Mr. House?
No, Your Honor.
All right, very well. You can include that in the order, Ms. Gillette.
Again, as I addressed in part one, I do not make money on my videos. I'm not monetized. I don't collect money from YouTube. I don't ask for donations. I do this on my own free time, out of my own free will, when I see injustice that needs to be exposed. So the fact that Jill says, well, it would be to make money off of, I don't make money off of these videos, and I don't plan to.
Temporary ex parte injunction protective order to maintain status quo. Have we covered your concerns there, Ms. Gillette?
That was that the further dissemination of any affidavits, anything like that must be destroyed. Anything that's already out there should be removed.
Now what you see here is Jill trying to get the court and this judge to make an order to force us to take down our videos. And you're going to see the judge just basically saying, no, we don't have any control over that. We only have control over this here and this now. I find it quite hilarious. Jill gets a slap in the face right here by the judge.
Removed. I don't know if we can make an order to all the online personas that are using the documents that are already leaked. Any further leaking? The status quo is the way it is as of today. No further information about the evidence in this case. The videos in this case should be leaked by the defendant as he's been leaking, because it messes with the jury trial and the ability to have a fair and impartial jury. And that is for both sides of the aisle, the defense and the state. His leaking, their commentary, it going rampant and viral, it needs to stop. And so I would ask for no further dissemination of anything in this case. The defendant.
Well, I have control over your office, Mr. House's office, and the defendant, Mr. Walker. How does my jurisdiction and authority go further than that for things that are already let out?
Yeah, I would ask that he cease. He has now started a new Facebook page, him and his wife, to try to disseminate things. You can clearly see he's posting as Bob Walker on that site over and over and over again, along with his wife. They're continuing to try to disseminate information about the case, make statements about the officers, make statements about witnesses. They've already slandered me with untruthful things on it, which opens them up to a slander suit, which is a separate civil suit that I may seek, especially since.
Jill, I'm glad you brought that up. I wonder, as you being elected official county attorney, I wonder what the law says of your character for slandering and making false accusations against me, Mike with Lawrence Accountability, Justin the Rabble Rouser, and all these other lies that you perpetrated right here in this hearing. Do you think, Jill, that you are legally bound and can be held accountable for those lies, slander that you just did here in this hearing that's now on court record? It's pretty interesting. Jill, it is an election year. You are right.
Especially since it's an election year. But that needs to stop. The further slander, pulling up stuff on the officers, disseminating stuff from the case, talking about the case on all these online things, he himself is doing it. He can shake his head no earlier all he wanted to, but he himself is doing it, making the post and encouraging his wife to. So it needs to stop. To keep the status quo of where we are right now with all the leakage that's already happened, it needs to stop so that we can have a fair and impartial jury. Otherwise, I don't know how we're going to get a fair jury.
Mr. House, your response?
I technically don't object to any of that. As I said, I've always wanted to try my case in court, not out on the street or in the newspaper. I don't do social media, so, but I understand it's a problem.
Well, the court is going to enter an order precluding all parties in this case, which I think was contemplated earlier, from disseminating any further information about this case until the case has been tried and completed. I agree that there's the potential interference with being able to get an impartial jury if people are trying to try their case in social media or making comments regarding various participants in the case while this case is pending. So in essence, this is a gag order on Mr. Walker, Mr. House, and Ms. Gillette in her office from further disseminating any material or information regarding this case, with the exception of scheduling information. And speaking of that issue, there is also a motion before the court to continue this trial, which I hate to do. I would like this case reach a conclusion and be over with. But in light of the late or certainly belated turnover of the medical records, which I think reach a critical issue in this case by the state, and failing to provide that to the defense in a timely fashion, I think it's patently unrealistic to expect that the defense can be prepared for trial by next Tuesday. I will say, Mr. House, you apparently have been diligent in identifying your expert. You know where these records are eventually going to go, correct?
Yes, Your Honor.
Are you a BIDS appointed lawyer?
Yes.
Have you sought approval from BIDS for this expert?
I've not had contact with him yet.
Okay, you've identified him. All right. Well, you're going to have to act on that promptly with
because
BIDS.
he's the doctor for Mrs. Walker. She has a back problem. She goes to a specialist in Tulsa, and he indicated he would be willing to look at medical reports and give his opinion.
All right. So again, Mr. House, I don't want to have to move it again. So the sooner we can act on these medical issues. Ms. Gillette, at what point can Mr. House count on him having access to the medical records which are in your possession, what we've called the California records?
The records can be scanned in and emailed to him if we need to. I can put them in a file where he has access to them. Or if Mr. House is going to be anywhere near Elk County, we can do a paper copy for him.
I would prefer a paper set that Mr. House personally picks up from your office.
We can make a copy of them in my office and he can pick them up anytime after today. My secretary's there right now. In fact, she's on here. So
Will you be making a trip to the courthouse next week, Mr. House?
I'll be able to get up there one way or the other next week.
Okay. I appreciate that commitment, counsel. The sooner we get the records turned over to you, the sooner you're in a position to refer them to your own medical expert.
All right. Thank you, Judge.
Ms. Gillette, I will ask you to draft an order documenting the various rulings that are made here today, since primarily these were your requests.
Judge, one other request. No third-party contact. When it says no contact with victims, that should include third parties. These online personas that are acting and getting information from the defendant and his family, they have been coming down, live streaming from the courthouse or within the county, trying to call and record phone conversations with my office, the sheriff's office, calling the offices in the Elk County Courthouse. They are victims of the disorderly conduct. Let me make that clear. The victims of the disorderly conduct is not Deputy Bliss. The victims are all the offices in the Elk County Courthouse that expressed concern over the defendant's behavior and did not want the courthouse doors opened. Them recording in their offices, sticking phones in their faces and asking them questions, calling them Nazis, Nazi baby killers, the B word, the C word, repeatedly calling their offices over and over again till we have to hang up on them 4 and 5 times. Even one of the deputy court clerks heard how extreme he was, and calling their office repeatedly would not be appropriate. These personas are working on his behalf and in his contact. They are intimidating the witnesses, in which I am looking at charges for intimidation of a witness for. That is third-party contact on his behalf. At this time, it needs to stop.
Okay, what I'm going to address here is pretty blatant. What Jill is asking is that you guys, because you watch these videos, you've seen all the videos of my videos, Mike, Lawrence Accountability, Rabble Rouser, anybody's videos who's covered this story. What Jill is asking is that you do not go down to this courthouse or the sheriff's department. You do not make phone calls, emails, and redress your grievances with your government. She just stated right here, the ones that were victims of a disorderly conduct from Robert redressing his grievance with his government are public employees. They're government employees, which is protected by the United States Supreme Court, that you have the right to redress grievances with them. Just because they don't like how you say it and the words you use to express and redress your grievances does not make it a crime. And Jill is not going to sit here and tell you that, oh, no, because that helps her case. This is one of the main arguments that need to be argued in this case, is that they are public employees. They're members of the government. You have the right to redress grievances. You have the right to record them in the course of their duties. Smith v. Cummings, Houston v. Hill, your right to redress your grievances and use any words and language as long as they're not fighting words or threatening. Cohen v. California is another one that says you have the right to redress grievances and use words. This is mind-blowing that she's sitting right here saying, oh, don't redress your grievances. We don't want that. We don't want transparency. We don't want accountability in our government, and we're not going to stand for it. And we're going to prosecute Robert Walker Jr. to prove we don't like you redressing grievances with us. It's sickening, and it really pisses me off. Let's continue.
Court will certainly issue an order precluding Mr. Walker or any member of his immediate family from soliciting third parties for purposes of harassment or intimidation of witnesses in the manner in which the prosecutor describes. In other words, Mr. Walker, you're not to have third parties do what you can't do.
No.
As far as restricting person's behavior at the Elk County Courthouse, the Elk County Courthouse, by and large, is under the control of the commission and the individual department heads as to what their policies might be regarding access by the public or recording in their offices. That's not a matter for the court unless it involves specific district court areas.
Judge,
Yes, Mr. House.
as to the motion I filed, I'm assuming since you've ordered that we continue the trial so that I and my client, or that I and the expert can review the medical records.
I'm denying your motion to dismiss that count for failure to provide those records. There's
Yes.
another remedy that the court has fashioned here that
Yes.
will ensure your client a fair trial on that count. So at this time, I'll deny your motion.
All right.
And
I understand.
obviously, the state has acquiesced in regards to your other motion regarding amendment of count 3. And I think those were essentially the matters that your motion addressed.
There was a motion to dismiss, which we can take up at the next pretrial, based on the fact that my client was not brought before a magistrate for 6 days.
Have you filed a written motion? Mr.
Yes,
House? And that's never been ruled upon?
Judge
Magistrate court or the district
Judge
court?
Lee decided to not rule on it and let the judge who was going to try the case rule on it.
There's a motion filed August 10th, 23. A response by the state was filed August 15th of 23.
All right.
And we don't need to take it up today, but I wouldn't.
Thank you for bringing that to the attention of the court.
All right.
All right. Very well then. Anything else, Mr. House?
No, Your Honor.
Or Ms. Gillette?
No, if you want to schedule a motions hearing for that, we could pick a date today. I would prefer it be in person, Your Honor. That was part of also my motion was to have all future hearings in person at the courthouse.
I'll have to check my schedule and get back with counsel then.
Okay.
Actually, I may be in a position to be able to issue a written ruling on the motion that Mr. House previously filed.
Your Honor, and I don't object to that procedure. You've got the state's position, you've got our position. I'm sure you're
Fairly straightforward issue. All right. And I do appreciate the state filing a formal response in the case. I'm sure that there is an explanation that is contemplated therein. If I do decide to have a hearing on it, counsel, I'll take under advisement to request that it be done in person. That very well may be desirable. Counsel, either one of you, anything further we need to address on this case at this time?
No, Your Honor.
No, Your Honor.
All right. Then if there's nothing further, the Robert L. Walker Jr. matter stands continued until the November trial date established today, and the proceedings will be in recess at this period.
So there you have it, the conclusion of part 2. Jill lying to the judge, lying to court on transcripts, making accusations, false accusations at that, against myself, against Robert Walker, against Robert Walker's attorney, against Mike with Lawrence Accountability, Justin Rabble-Rouser, and all of us other independent investigative reporters that are out there that has covered this case. That we have released some medical documents that we don't have. And after we looked into it, and you see earlier that the information we got was from the very Zoom video that the 13th District and Jill allowed to be published on YouTube. And there's timestamps of all the information and where we got it, how we got it. We have no documents of any medical records, never have. And I find it very, very interesting. Jill is doing her darndest to try to get our videos taken down, try to silence our free speech and our right to free press. And she's doing everything to try to keep this case from being exposed, their corruption from being exposed. And I find it not only kind of humorous on one end, but kind of makes me very frustrated and angry on the other end, because this is what our government is doing to all these people nowadays. I mean, this is not just here in Kansas. This is not just in Elk County, Kansas. This is happening. Mike with Lawrence Accountability seen it in Lawrence. It's happening all across the country, not just here. And if you don't have a decent attorney or somebody who can look into these cases and dive in and dig in and really get to the core roots of what's happening and put boots on the ground into these locations to expose it, you guys would never even know this was going on. People would say, oh man, I'm getting railroaded, but you would have no way of knowing. But that's why we are here. We're here to expose it and to let you see what your government is doing to the taxpayers. Makes me sick, guys. Well, that will conclude part 2. I apologize for it being so long. I apologize for interrupting as much as I do and have, but this really ticks me off, and it should tick you guys off too. And it should make you want to stand up, get your phone and video cameras out, and start documenting all your encounters and start exposing this. Always record the police. Always have to stand up for your rights. Because if you don't stand up for them, they will take them like they're trying to do here, little by little, case by case, false charges after false charges. They will strip you of your rights. Well, that said, this is Richard, Kansas Freedom News. God bless.